Consequences of dying without a will in Cherokee County. When a person dies without a will in Oklahoma, they are considered to have died intestate. In Cherokee County, this means the law, not the individual, determines who receives their property, who manages the estate, and how assets are distributed. While Oklahoma provides a default system for handling these situations, that system rarely reflects the complexity of modern families or individual intentions. Understanding the consequences of dying without a will is essential if you own property or have dependents. Oklahoma's intestate succession controls distribution. When there is no will, Oklahoma's intestate succession statutes dictate who inherits. Courts in Cherokee County do not consider verbal promises or informal understandings. Instead, they follow a strict order of heirs. In many cases, a surviving spouse will inherit a portion of the estate, but not always all of it. If there are children, especially from prior relationships, the estate may be divided between the spouse and those children. If there is no spouse or children, the law looks to parents, siblings, and more distant relatives. This rigid structure often produces outcomes that families did not expect. Your property may be split in unintended ways. One of the most significant consequences of intestacy is how property, particularly land and homes, is divided. Instead of passing cleanly to one person, property may be split among multiple heirs. This can result in several individuals owning undivided interests in the same property. In practical terms, that means each heir has rights to the property, but no single person has full control. Disagreements frequently arise over whether to sell, maintain, or occupy the property. In some cases, one heir may file a legal action to force the sale of the property, even if others want to keep it. Probate becomes necessary. Without a will, there is no designated personal representative to handle the estate. As a result, the estate must go through probate so the court can appoint an administrator. During probate, the court determines who the legal heirs are, oversees the payment of debts and expenses, and orders the distribution of assets. This process can take months or longer, particularly if disputes arise or if the estate includes complex assets like real property or business interests. You lose control over who manages your estate. When you die without a will, you also lose the ability to choose who will handle your affairs. The court appoints an administrator, typically based on statutory priority. While this is often a close family member, it may not be the person you would have selected. This can create tension, especially in families where there is disagreement about how the estate should be handled. Guardianship issues for minor children. If you have minor children, dying without a will leaves the decision about their care to the court. While the court will act in the best interests of the children, it will not have the benefit of your explicit wishes. Family members may disagree about who should serve as guardian, and those disputes can lead to contested proceedings. A properly drafted will allows you to express your preferences and provide guidance to the court. Increased risk of family disputes. Intestate estates are more likely to result in conflict. Without clear instructions, family members may have different expectations about what should happen to property and assets. Disputes can arise over who is entitled to inherit, how assets should be divided, and who should serve as administrator. These conflicts can delay the probate process and increase costs, reducing the overall value of the estate. Potential financial consequences. Dying without a will can also create financial inefficiencies. The probate process may take longer, administrative costs may increase, and property may be sold under less favorable conditions due to disagreements among heirs. In addition, assets may pass to individuals who were not intended beneficiaries, while others you may have wanted to provide for receive nothing. Cherokee County Estate Planning and Probate Attorneys. The consequences of dying without a will in Cherokee County extend far beyond simple inconvenience. Intestate succession removes your ability to control how your property is distributed, who manages your estate, and who cares for your children. For a free and confidential consultation with one of the probate lawyers at Kania Law Tahlequah Attorneys, call 539-867-2321.